Hello, and welcome to the second episode of Season 6 of Law and Candor, the podcast wholly devoted to pursuing the legal technology revolution. I'm Rob, and of course, I'm here with my co-host, Bill Mariano. Have an interesting conversation today. Really, we've had this issue of cross-border data transfers and, EU-US data privacy, tug of war. This is something that we have talked about before, but it continues to be relevant, so we're really excited to get into this with our guests. But before we do that, of course, we have to go to our
Sightings of Radical Brilliance.
Of course, you know that this is the part of the show where we talk about technology and other innovations that we think are cool. And Bill, what are we up to today?
In thelawyer.com, we have an article written by the brilliant and devastatingly handsome John Shaw of Lighthouse in our London office. John writes about the trends analysis, in new sources of evidentiary data in employment disputes. And the article highlights the challenges arising from increased use of collaboration and messaging tools by employees now that we are all in quarantine and working from home. It's actually an interesting take. I think, having discussed this before, Rob, everyone's working from home. I know this is a theme in our sightings. We've been talking about this a lot. Almost every sightings we've done in the last season or two have discussed this in some form or another, and why not? I mean, it's the topic of the day, but this has to do with these new sources of evidentiary data that are just more casual, right? More of that chat data, it's just more casual, and working from home, it's going to lead to an intermingling of personal and professional information being shared.
Well, and there's kind of like this progression that we've seen happen over the last, I guess it's been 20 years, where like you used to write a memo, and that memo was really formal and you thought about it. And then we started to communicate through email, where things got a little more casual. And now we've just continued to go right. And now we're chatting and we're working in these collaboration systems. And not just that, but we're doing it from home. And it really just introduces like that intermingling of work with personal. And on top of that, this stuff is just a lot harder to go out and collect and find.
Yeah. And, in terms of the intermingling, the chat is much more akin to a phone conversation because it's immediate, right? You're going back and forth, and I know about some of the chats that I've been on where you're talking about things professionally, and then all of a sudden you're like, hey, how was your daughter's graduation, by the way? I know you were doing that this weekend. And, and then it's back to work, and then it's back, and it's just like a phone conversation. So, when you go out and you have to collect this stuff, you have to sift through personal conversations as much as you have to sift through professional, while you're in search of professional conversations that might be within the scope of a litigation or investigation. And it's going to make things even more difficult because of the way you have to collect this stuff. It's not necessarily just running search terms or letting TAR tell you what's relevant. Collecting this stuff creates the opportunity to over-collect because the stuff you're looking for is so intermingled with the stuff that you don't care about.
Yeah, and it just makes it easier to take things out of context. When you're in that thread or you're in that chat and it's shifting back and forth between personal and work, it just really creates that danger. And then you throw in emojis on top of that. And,
yeah.
A lot of our development stuff that we're working on today is, how do we better process these chats? How do you create a system that can really, analyze these emojis? Just getting harder and harder out there.
Yeah, that always cracks me up. So, hey, what do you think of this document I just put together for the strategy on X? And you get a thumbs up back, or you get a middle finger back, and then you have to interpret that, right? So, yeah, you're collecting it is certainly a challenge. But again, just the intermingling of the personal and professional language and vernacular within the individual chats, as opposed to the memo from days gone by, as you mentioned, or even an email where you actually think about what you're going to say, make sure that you're saying it in the voice that you want to say it in, and then hit send. The chat is more like text. It's more like a phone call. It's more informal. You're weaving in and out of the personal and the professional, and collecting that in a way where you're just focusing on the professional proves to be challenging.
Yeah, super hard. Big challenges for our clients moving forward, but
Yeah, and I guess the best thing to do, is just to wrap some policy around it. But again, I think it's just going to be one of these issues that you're just going to have to be wary of, and make sure your employees are not every employee goes to work wondering about whether or not their data is going to be looked at because of the purposes of litigation down the road. So it's just got to be something you drill into their heads.
Well, and I mean, you can create a policy and you can say it, but we saw this with email a long time ago where from the time when people started to use email to the time when people started to realize how often that was going to show up in a litigation and that they were going to be sort of held accountable for the stuff they said, like a long time passed. And I think with chat, it's the same thing. This stuff is going to come back to haunt people. But by then, we're going to be several years into the future, and it's tough.
Yeah, agreed. All right. So check out the article. It's interesting. And John, shout out to John. He did a great job on it. And you can find it on thelawyer.com, trends analysis, new sources of evidentiary data in employment disputes. Let's get to the interview portion of the program. So we had the great pleasure of speaking with Melina of Eversheds about cross-border data transfers and the EU-US data privacy tug of war. Let's jump onto that recording now. I think you guys are going to love it. It's a really interesting conversation. All right, today we are talking about cross-border data transfers and EU-US data privacy, the tug of war between the two. And to join us, to walk us through this, to educate us, to show us what's what and tell us what's happening, we have Melina Efstathiou, and I won a gold medal for even getting close on your last name. If you want to buy a vowel, she's selling them. She's got 1 million of them in her last name. Melina, thank you so much for joining us today. We really appreciate it.
Thank you.
Yeah, the question we've been starting off with in this stuff, only because it's super interesting. No one goes to university to get into e-discovery, right? No one says, hey, I want to get to the e-discovery industry. What course is going to take in high school and college and university to get into that? So tell us a little bit about how you ended up here, not necessarily on this podcast, which I'm sure is the highlight of your life, but how did you get in the industry?
First of all, I'm a little offended because I did plan for this my whole life and I don't know what you're talking about.
Yeah, I've got no idea what sort of life Bill leads, but let me tell you, this is the highlight of probably the year, if you do really consider what year we've been having. First off, kudos on the surname. I've already got your address down and you're getting a nice little Christmas hamper of some sort. I do have all the vowels of the alphabet, of every alphabet, may I add. How did I get into technology? I mean, law to technology is really not that uncommon anymore of a transition, but in a nutshell, I'm a multilingual, dual jurisdiction qualified solicitor. And through the years of my practicing law, at some point, I found myself starting to get involved with document reviews and document review management because they needed people that would understand cases from 2 points of view. Long story short, I fell in love with technology. And then I thought, maybe there's a career tied to it. Little did I know, fast forward some 10 years in the industry, that I would be sitting here essentially saying all of you that it's legitimately the best decision I've ever made. I think if one considers the latest circumstances and just overall surrounding circumstances, the hybrid model of professionals such as myself, I think I've got a unique view of law and understanding of law and equally, obviously, an expertise in technology, and they're able to grasp those things better.
I'm not sure if you were trying to make us look like underachievers here, but well done. If you were, well done. I appreciate that, by the way. I wasn't feeling horrible enough about myself today.
Yeah. Unfortunately, a common occurrence on this podcast, but that's good.
I thought that was the whole purpose. I signed up for that. Just make sure I berate both of you.
Thank you.
And then just, wander off.
Yeah. Yeah. Bill and I were always confused. Like, why did they pick us to do this podcast? And now it all makes sense. It's really to make you look better. So
and we take it as well. Yeah.
100%.
Well, Melina, a question just to kind of jump into our topic. I think we wanted to start off with a discussion about what many people saw as a surprise decision from the European Court of Justice invalidating the US-EU Privacy Shield. Just curious on, your thoughts of this and, what it means for those of us that, however we got here, ended up in e-discovery.
Yeah, no, of course. Prior to exploring the surprising decision, to say the least, the Privacy Shield, because obviously it's not a cross-border discussion if we don't pronounce words in a different way. So your privacy is my privacy. The Privacy Shield framework essentially provides for the possibility of lawful transfers of personal data from the EU to the United States. And it's been there, for a considerable amount of time. And that brings us, of course, to July 2020, the Schrems surprising decision, quite a landmark decision, if you don't mind me saying, as the court legitimately rendered the EC's Privacy Shield decision decision invalid. It basically said that the US is too invasive. It doesn't provide sufficient protection for individuals whose data has been transferred from the EEA to the US and is no longer valid. Further than that, the court equally stipulated stricter requirements for the transfer of personal data, even when you're basing it on standard contract clauses. Data controllers or processes that intend to do that, they still have to satisfy a great deal of safeguards to be compliant with the GDPR and the overall European Union guidelines, if that makes sense. So in a nutshell, anyone handling cross-border cases needs to be fully aware of what I just tried to succinctly mention, all the parameters when they're advising towards data collections, data transfers, security around them, and if they're actually feasible or not.
So then how does this impact data transfer mechanisms?
Right. It does quite heavily, to be honest. You can clearly see that the court's been on a mission for quite a few years recently to be quite persistent in strengthening the level of protection around personal data. So, obviously when you're dealing with commercial disputes and what have you that spill across the ocean, the understanding is that the EU companies can no longer legally transfer personal data to the US based on the Privacy Shield, what was previously known Safe Harbor, et cetera, et cetera. You still have your, sliding door situation and your loopholes with your SECs and your binding corporate rules and what have you. But again, you need to provide additional safeguards. So when it comes to data transfers, encryption methodologies and other technology measures are already subjected to heavy scrutiny. There's a lot of skepticism and a lot of articles and dialogue, out there in terms of concerns around their actual efficiency. So I think you're going to end up having a more ad hoc assessment of things versus we are covered on that basis and we're good to go. It's most likely we're prohibited. So what can we do to actually satisfy additional requirements?
And I guess, Melina, like if that wasn't complicated enough, let's make it even more complicated.
Of course.
How do you sort of factor in, Brexit into this analysis?
Brexit, of course, because you have the SECs, the BCRs, the GDPRs, and everything else, and all the acronyms that ediscovery can handle. Brexit is a big deal. Data privacy has already been on the rocks when one considers that the UK will no longer be part of the EU come January 2021. I have a ticking countdown clock, believe it or not, on my desktop that tells me that today it's 50 days remaining in the Brexit transition period and all the countries getting up to speed with whatever it is that they need to do and all the parameters that they need to be put in place. But in all essence, come January 2021, the UK would need to go the extra mile to satisfy safeguards in terms of personal data and the transfer from inside the economic European area to outside the EEA, which is what UK will basically end up being part of. The UK will be considered a third country, and then that will see the country having to gain an adequacy decision so that personal data transfers are indeed allowed. There have been provisions incorporated in the Data Protection Act that are part of, as I said earlier, the Brexit transition period and what have you. But then you do have the skeptics, and quite a lot of them are indeed in our industry because we're dealing with surveillance and data and what have you that say that UK already conducts quite extensive surveillance for the purposes of national security. So that again would be deemed as quite the invasive measure and something that basically ended up resulting in the Privacy Shield being overturned by the Schrems decision that we were discussing in the first place. I would say personal data transfers post-Brexit would no longer be an easy case at all. It would be quite the complex process to go through. UK will indeed be treated as a third country. UK to EEA, you'll be okay. EEA to UK, if anybody can actually say that back to me, I will, applaud them, will fall under a general prohibition. So that means that any business that wants to do personal data transfers, they would really need to have a much better mechanism in place.
We have a bibliography attached to this podcast with all the different acronyms so that our listeners can go to it as a reference because there are just so many.
Yeah, I think they're going to need to.
And when I combine that with your last name, it's just there are vowels flying everywhere.
Yeah.
So what we like to do when we wrap these podcasts up is to give some tips and guidelines to our listeners, for preparing for future like cross-border e-discovery. So as a baseline, we've taken a poll, and every single one of our listeners is smarter than me. So if you can teach me how to do it, every one of our listeners will get something out of it. So any tips, guidelines for the future of cross-border e-discovery?
Tips and guidelines. Absolutely. I mean, joking aside, I would say you need to study your data privacy guidelines carefully, and you need to remain overall informed and up to date. You need to scrutinize heavily IT questionnaires in relation to cross-jurisdiction or cross-border cases heavily, and flag issues with custodians whose data is held in the US or might be held in the US as early as possible. And the vice versa, of course. And you need to be able to suggest to your clients a revision/update of their data mapping and ask them if they really know where their data resides. I genuinely don't think that all entities are actually ready for what is coming, with Brexit looming and everything else. And then this decision has basically helped solidify what everybody was dreading to begin with, that there's not enough safeguards. This is not a willy-nilly exercise. Here's my data, there's your data, push it from the European Union to the US and back and forth. It's a much more complex process to begin with. So those would be my tips, I think, and good luck to all of you for that matter.
Yeah. Good luck. Definitely a good way to end this, because I don't know how this is all going to turn out. But we want to thank you for being on the podcast. Maybe just to sum up, in case there are any 5-year-olds listening to the podcast, I'll put this in language that they'll understand. Clearly the revocation of the privacy shield, was that better?
Excellent. Top marks.
We'll have a lot of implications when you think about the extra burden that having to have this more ad hoc case-by-case review of matters. I think that's going to create a lot of potential issues. Make that even more complicated by the additional restrictions on data transfers, especially coming in and out of the UK. I think your guidelines were perfect in summing things up. I think our listeners, like Bill mentioned, really, really do appreciate that, and just want to thank you again for being on the podcast. It's been great.
No, thank you. I really appreciate it. I mean, I'm not going to put you on the spot and try to make you pronounce my surname, because I genuinely think you need to practice.
I gladly will take that challenge. Efstathiou.
I know you've cheated. I know nobody gets it first time round. We've spoken before, but we've spelled
it out phonetically with an F, a staff, and an EU. That's
absolutely.
Basically
I bet there's post-its like in front of you saying Efstathiou. That's exactly how it goes. But as I say, we all have a little Greek inside us, whether we know it or not. So
my only word of advice, if you're going to be on other podcasts, is break out of your shell a little bit, become less shy, become more charismatic and talk a little bit more, because I feel like you're just, you're too bound up, you're too shy. You really need to come out of your shell and know your subject matter more.
I really do, don't I? Yeah. I don't seem to be making it across as efficiently as I should. And hey, Rob, by the way, that 5-year-old, if any 5-year-olds are actually listening, I'd like their CV, please, and everything else, because I am, I'm in need of more intelligent youngsters in my team. So that will be great.
Melina, I think you'll be a perfect guest next year for season 7. I think what we're going to do is we're going to do drunk lawn candor, and we're going to drink wine and talk about these subjects. So if you want to be invited to that, I think we'll get a couple of Greek Reds, and we'll down them and just see how this all turns out.
Absolutely. It's already drink o'clock, and as far as I'm concerned, you'll be the ones out of order. This time zone thing just works perfectly for me, So as long as it's your afternoon and my evening, I'm game if you are. No problem at all.
Perfect. This has really been great. Thank you so much for joining us. I really appreciate it. I think this is going to be, I think our listeners will get something out of this and maybe even laugh a little bit. Really appreciate it. Thanks so much for doing this.
Thanks.
Thank you. Thanks, everyone. Bye-bye.
All right, kids, listen, no free lunches. If you like Lawn Candor, if you love Lawn Candor, Be sure to subscribe, unsubscribe, resubscribe, smash that button. Whatever the kids say to do, you do it. We need you to do it. Why do we need you to do it? Because they're going to get rid of Rob on the podcast. They told us there's room for one of us unless we get enough likes. Obviously, it would have to be Rob. Please smash that button. Subscribe, unsubscribe, resubscribe. Tell your friends, tell your family. Get it done. Lawn Candor so we can hit season 7 because we have a bet with people on whether or not we will reach season 7, and we want to win that bet. Thanks.